Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is, can we define overlapping markets? Understanding the legal and economic arguments with Keith Klovers. And joining me today is my co-host, Blair Matthews. Hi, Blair.
Hi, Anora.
So today we're talking about overlapping markets, however that's defined, and whether they make sense economically. Why are we talking about it?
So our guest today, Keith Klovers, co-wrote an exemplary article with Jonathan Jacobson arguing that courts should reject the use of overlapping markets, sometimes referred to as submarkets in the antitrust parlance, because overlapping markets are economically incoherent and have a weak legal foundation as well.
Well, it's always good to keep up with the most recent publication. Would you please introduce our guest speaker, Keith, to our listeners?
Absolutely. Our guest today is Keith Klovers. Keith is counsel in Latham and Watkins Antitrust Group. He has represented clients across a variety of industries, including healthcare, life sciences, and technology, in merger reviews, investigations, and litigation as well. He previously served as an advisor to FTC Commissioners Christine Wilson and Maureen Ohlhausen, and as a law clerk for Judge Douglas Ginsburg on the U.S. Court of Appeals for the D.C. Circuit.
Great. Keith, welcome to the program.
Thank you. Yeah, and thanks for having me. Great to be here.
So to start off, I think Blair already previewed. You wrote an article, both Claire and I, we read it. We think it's a great one that we should share with the listeners. But would you please tell us what drove you to write an article? What first made you interested in the issue of overlapping markets?
Sure. Yeah, glad to. And thanks again for having me. And frankly, a lot of this came from some work that I did with John Jacobson, just thinking about these issues. So, he is very much a part of this conversation as well, although he's not here today. Why define these overlapping markets, or kind of why did we become interested in this topic? I think it's a fundamental question in antitrust, where, to start with, what is the relevant market, right? Because that determines who your competitors are, what your market shares are, and what kinds of conduct is going to be permissible. So it's a fundamental question in many cases. And when I was at the Federal Trade Commission, it was something that we were confronted with all the time, right? You'd get commentary, you'd get advocacy from the parties, but you'd have to kind of make a decision. What do you think the market really is? And so as part of that process, especially when I was working with Christine Wilson, or Commissioner Wilson, we noticed that markets were narrowing over time. If you looked at the historical precedents relative to the cases today, the markets were getting narrower and narrower and narrower, and the market shares were going up. And so, to give you just one example in grocery, in the 1960s, we had the Vons grocery store case where the relevant market was defined as retail grocery. By the 1980s, we had American stores, and the market became supermarkets. And by the time we got to the 2000s with Whole Foods, the relevant market was premium, natural, and organic supermarkets. Smaller market, higher market shares. And so we wrote an article, Commissioner Wilson and I, kind of documenting that fact and thinking about some of the consequences. But what was really interesting is at the end of that article, kind of the very most recent cases, we were starting to see a divergence in that trend. We were starting to see cases where folks were defining both a narrow market and a broader market at the same time, kind of an overlapping market, which didn't really fit with the paradigm and seemed a little bit unusual. And so that really spurred my interest in digging in a little bit further. Why are we seeing that divergence?
It's really interesting you've been thinking about these issues, Keith. I think it might be useful to take a step back and just give a little bit more background to our listeners as well. I think a lot of our listeners are familiar with what market definition is and the central role it plays in antitrust analysis. But do you think you could bring everyone up to speed and tell us a little bit about what an overlapping market is and the effect using it has on the antitrust analysis?
Absolutely. So first, what is an overlapping market? I will tell you kind of the layman's version. The way I think about it is as a Russian nesting doll, where you open up one market and there's another one inside of that, and then you open that one up and there's another one inside of that. The agencies are a little more eloquent than I am. And so in the 2023 merger guidelines, they have an example that they use as kind of their paradigm. And it illustrates, I think, kind of the breadth of the concept, at least in the way that the framers of that document intended it. So they have 5 nested markets in the merger guidelines. And the outermost one is food. So they allege that there could be a market for all food with competitors and market shares. And then within that, there'd be a market for baked goods. Within that, there's a market for cookies. Within that, there's a market for low-fat cookies. And finally, the kind of the smallest Russian nesting doll is for premium low-fat chocolate chip cookies. And so that is the description that we have been given. I would say, the move towards having 5 different markets is a little bit unusual. More often we see 2 or 3 permutations. But there's variance, and I think it's something that we're seeing play out in real time. I think there's a little bit of a question then of, well, what's the effect, right? And I think historically, there wasn't much of an effect. I think it came out of this case, Brown Shoe, in 1960s. And the reason I think that the Supreme Court came up with the idea of submarkets is they were trying to harmonize older cases. There had been one DuPont case alleging a very broad market, the cellophane case. There was then a subsequent DuPont case alleging a very narrow market. That was the DuPont GM case. And then, the court is presented with this Brown Shoe fact pattern. And I think rather than having to overrule one of their own cases that they had just decided, they said, well, let's do both. There might be cases when broad is appropriate. There might be cases when narrow. I think the problem for us, at that time in the 1960s, it really didn't matter whether the market was broad or narrow. As Justice Stewart said in dissent in Bonds, the only consistency is that the government always wins. So it didn't matter, right? The government would allege whatever market they wanted and they would win. That started to change as the economics took hold. In the 1980s, we start to see the SNP test, the hypothetical monopolist test, and some of those. And so we start to come down to the idea that maybe there's just one relevant market, right? That economics is going to point us to the right answer. And so the problem with going back to an overlapping markets framework is it turns what had been kind of a pretty simple test into a multiple choice exam, right? Rather than the market being A or B or C, the market is now A and B and C. And I think Tim Wu said it best. So in 2019, he was kind of recognizing the way that market definition affects the analysis. And he said, as everyone knows, it is nearly always possible to manipulate market definition to justify deciding a case in a particular direction. And so that, I think, is fundamentally the concern. Is if you make it a multiple choice test, you're going to find some permutation where the conduct is unlawful, even if that were not the case before.
That's really helpful, Keith, and I think the description is really useful. I know you touched a little bit on this already with respect to kind of the development of the economic thinking, but could you walk us through the economic criticism specifically around this overlapping market concept and why, as one economist you cite, would use overlapping market essentially to call it a return to the dark ages?
Sure. Yeah. And that economist was Greg Worden, who was at the Department of Justice for a very long time and is kind of viewed as one of the grandfathers or the godfathers of the hypothetical monopolist test. I think what he was talking about, and I think, we talk about it some in the paper as well, is the idea that ultimately market definition is trying to decide whether the defendant has market power, right? And what quantum of market power they have. And so it is supposed to be a test that comes up with an answer. You have a little bit of market power, you have some market power, you have a lot of market power, right? And that's why, when we're counseling clients, if the client has 5% market share, we're going to give different advice than if the client has 95% market share. But economically, going back to the dark ages, as he put it, it is because we're no longer giving a clear answer if we define overlapping markets. And so, normally when we think about the SNP test and the hypothetical monopolist test, we are thinking about demand substitution. How are customers reacting? What are the available substitutes for customers? And how are they making their decisions? And so we kind of throw all of that out the window if we go to a multiple choice test. So if we look at the economic evidence, for example, with cookies, and we find that the pricing for Chips Ahoy cookies is constrained by Oreos because lots of people will substitute to Oreos in response to a 5 or 10% price increase, then they should be in the same market. Or at least that's historically what we had viewed to be true. And what we're now being told with the overlapping markets concept is they are both competitors that constrain each other in a market for cookies, and they are not competitors because they do not constrain each other in a market for chocolate chip cookies, because Oreos are not a chocolate chip cookie. And it can't be both at the same time. They either are a competitive constraint or they're not.
I think that makes sense. And coming back to the Russian doll analogy, you cannot basically having the cases analyzed economically on the bigger outer doll and also the smaller inner nested doll. Is that basically it? But then you also, I think your article also argued that there isn't much of a legal basis for the use of overlapping markets. And then that discussion would have to come back to the case brown shoe. And then brown shoe is often used and cited as support for overlapping markets propositions. And then would you please walk us through why your reading of brown shoe and in your view is actually casting doubts on the use of overlapping markets?
Sure. Yeah. And I guess, the article could have been titled The Misuse of Brown Shoe, or at least the misunderstanding of it, because I think that's exactly right. So, why am I coming back to brown shoe? So that's what's cited in the merger guidelines, right? When the merger guidelines say we can define overlapping markets, there's one citation for that, and it's brown shoe. It's the same in most cases if you look at them. So what happened in brown shoe? Brown shoe, right, is a vertical merger case largely, with relatively low shares. What happened when it came up to the Supreme Court is there was a fight about market definition, right, as there often is. And the plaintiff said there are 3 non-overlapping markets. There's a market for men's shoes, there's a market for women's shoes, and there's a market for children's shoes. The defendant said, in addition to those are actually the wrong way to think about the market. There should be finer distinctions. We should be looking at price distinctions among different kinds of shoes. We should be looking at quality distinctions, maybe the type of distinctions, right? The idea is supposed to be a men's tennis shoe is not a substitute for a men's dress shoe, especially in different price points. And the Supreme Court emphatically came down on the plaintiff's side of that argument and said, no, there's only 3 markets. There's men's shoes, there's women's shoes, and there's children's shoes. There are no finer distinctions. That does not make sense. And so what's interesting about it is there aren't any submarkets in brown shoe. What was actually decided in that case was 3 separate non-overlapping markets. They're not submarkets of each other. They're completely separate. And, not only is it a case where kind of the court just didn't consider the alternative, like the court explicitly considered the alternative of a narrower market, whether it's within or as, an alternative to those broader markets, and rejected them. And so, to me, it's kind of like law school 101. This is not a holding, right? If they did not make a decision that is binding on that case, then how can that be kind of the legal principle that we would apply in other cases? So that's brown shoe, and we can talk about other cases, but that's kind of the primary authority.
That's helpful to understand, Keith. You had an example in your paper that I thought was really interesting, where an agency brings a monopolization claim in a narrower market and a nascent competition claim in a broader market. Can you help us understand a little bit how overlapping markets enable this type of situation, and also maybe give a little context on why that might be perceived as unfair to defendants?
Sure. Yeah, well, let me start with the example, and then we can talk about kind of whether it's a fair way to go. So, especially, say, 5 to 10 years ago, we started hearing a lot more about big tech cases. I mean, there were other kinds as well, but especially with big tech, there was a focus on both bringing monopolization cases alleging narrow markets and also challenging kind of killer acquisitions in broader markets, right? And we see this to some degree in pharmaceuticals and other places as well. The problem with that is, kind of in the olden days, you would say once we have a precedent that the market is narrow, the market cannot also be broad. And so as a defendant, as a company trying to comply with the law, you would say, okay, now I understand that I have a high market share in a very narrow market. And there's various business practices that I can't engage in there. But it also means I don't compete with these other companies and I can acquire them because they're not competitors of mine. The problem with overlapping markets is you throw out that legal certainty, right? Even if you are adjudged to be a monopolist in a narrow market, and which by itself, kind of by definition, means you are not constrained by all the other firms that are outside that market, you can still then turn around and be told that you're violating the law by acquiring those companies that were just determined are not competitive constraints.
Back to your previous comment, the government always wins, right? So we've talked a bit about economic and legal criticisms of the overlapping markets, and I think where does that lead to us, right? If overlapping markets is no good and there are issues with using it, what would be a useful alternative? And I think you co-authored a paper, proposed one, and that came from a much more recent case. Instead of the 1962 brown shoe, we now look at the 2018 decision, American Express. And then you think there is a rule that you can derive from that case that would work better. Is that right? Would you walk us through that?
That's right. Yeah. So let me start with, what is American Express? What's the rule that we derive from it? And then we can talk about how we might apply it. So American Express is a case I think everybody who's practiced recently has heard of. Went all the way up to the Supreme Court. We have that decision from 2018. So it's much more recent law than brown shoe or any of the other cases. In that case, what's interesting, I've read the Supreme Court decision many times. I had not read the lower court decisions until I was doing the research for this article. And so I think it's useful to rewind because that's probably part that folks forget. When the case first came up and was litigated at the trial court, the Department of Justice alleged submarkets. They alleged that there was a broader market for kind of card services. There was one on the merchant side, there was another on the issuer side, but then that there was also an overlapping submarket for travel and entertainment services. So the same service, but sold specifically to a travel and entertainment business. The trial court did not find that. When they rendered their decision, they focused just on that market and not on travel and entertainment. So they said there is no submarket. When it came up on appeal to the Second Circuit, and the DOJ was defending kind of the liability finding that they had, they got rid of the submarket concept. And they said there are only non-overlapping markets in this case, having just pled the opposite. But, I understand they were defending the judgment now that they had won. So when that then goes up to the Supreme Court, we have this context where submarkets were litigated and rejected. And then as we come up through the system, they're kind of forgotten about. But they come back in that case when we get to the Supreme Court level because the majority concludes that there is only one market and it encompasses both sides of the platform. So rather than looking just at the merchant side or just at the issuer kind of customer side, we have to look at both together when we're thinking about anti-competitive effects. And so the market encompasses both sides. And what's interesting is in dissent, Justice Breyer would have allowed there to be submarkets. So he would have allowed both kind of an overarching market that covers the whole platform, but also separate submarkets for each side of the platform. And that rule did not prevail. And so then, that to me is kind of the principle or the holding of that case then, is that in a two-sided transaction market, that's kind of the language that people use to describe cards like Amex, you can only have one market, right? And the question that we posed in the article was, well, why should that only be true for a two-sided transaction platform? Certainly it makes sense in that context, but can we bring that principle a little bit broader? And when we first started looking at it, we were constantly told, well, brown shoe governs this point. And Brown Shoe says you can have submarkets. And then, as we just talked about, when we looked at Brown Shoe, we said, well, we don't really see it here. And so it seems like we have Amex against a background where there is no strong rule. In terms of what is the rule then, the one market per transaction rule, what we propose is you can have multiple markets, they just can't overlap. So if you want to define a market for, it's a software market, let's say, and it's sales to Fortune 500 customers because you think, larger customers are more sophisticated or have different needs, that's fine. That can be a market. But you can't count those sales to those Fortune 500 companies again in a broader market for kind of all software sales to all customers. You have to carve it out. It sounds, I don't think it sounds particularly novel, and that's because it's not. And so I think the best example, there's many, but the best example actually comes from the FTC. When the FTC litigated the Cisco case several years ago, they called Mark Israel as one of their experts. And when he was doing the analysis, there were two markets that were defined. There was a market for kind of broadline services to local customers, and there was a separate market for broadline services to national customers, people like Subway that had a lot of locations and needed the same service everywhere. And when Mark was calculating market shares, he did those separately. He said, here is Cisco's market share and US Foods market share for those national customers and excluding everything else. And here are their market shares for kind of the local customers and excluding the national customers. And I think that's the right way to do the analysis.
So there is a lot to unpack here. And I think, but the highest principle that you're deriving from your reading is that the Supreme Court held that for a two-sided transaction market, I would even say even for a two-sided transaction market, because that's already complicated there. There, a given transaction can only be attributed to one relevant product market, right? But your thinking is that this rationale should be applied broadly, not just like, in the two-sided transaction markets, which I think makes sense. But I think that principle is worth reinforcing. Could you walk us a little bit, like, how would that principle be applied broadly, and why should that be?
Sure. So I think, if we go back to the idea of competitive constraints, when we're thinking about market power, right? Fundamentally, the idea is, if we're talking about the Fortune 500 companies, right? There might only be 3 enterprise resource planning software programs that they can use, right? ERPs. And so those are the 3 competitive constraints that they consider. That's a market, right? And you can calculate market shares in that. They don't also consider some of the smaller players, right? So there might be some smaller programs that aren't going to be used or usable by the Fortune 500 companies. So you might have one market with the competitive constraints for the Fortune 500, but they're not being constrained by other products, so it doesn't make sense to put them in the market. Conversely, if you're looking at a small or medium business, they may have different options, and their pricing decisions may be informed by different substitutes. And so fundamentally, the idea is simply we're going to draw markets around substitution patterns and around constraints. And once we've drawn that market, we're not going to double count it somewhere else.
I think it makes sense. It's just conceptually, it's hard to think something falls into a market and then it falls into yet another market, which is not overlapping. How would that be? Are they adjacent or are they back to back? That dot has to fall into some circles. That's what I'm thinking.
Oh, so I totally agree with you. And one thing that I mentioned in the article we hadn't mentioned yet is beer. So I grew up in Milwaukee. I grew up near all the breweries. And so to me, there's a 1960s case about submarkets in beer that I think it kind of reflects this point. So there's the Pabst case, right, where Pabst, which was a Milwaukee-based brewer, tried to buy Blatz, which was another Milwaukee-based brewer. And that case was litigated in district court. DOJ put on their case for a total of 1 day. They did not call any witnesses. It was all done on the papers, but they alleged 3 overlapping markets. They said that there's a market for beer in Wisconsin. There's a market for beer in Wisconsin, Illinois, and Michigan. And there's a market for beer nationally. And that was litigated before the district court, which rejected it, said there's simply no evidence of that. It's a national market. And when it went up to the Supreme Court, as we know, because the government always wins, at least in the 1960s, they came back with all three markets, even though there were no factual findings to underpin that. But I think it shows kind of the intellectual problem, right? Which is, if you are a wholesaler and you're selling beer in Wisconsin, how can you also be selling beer in a regional market and a national market? You're going to have different constraints. And so, the consumer is either able to purchase and substitute to beer brewed in California and Texas, or they're not. It's kind of a binary question.
That's very interesting. And I think it is interesting to kind of compare that to the Cisco case where, we're defining markets around customers, right? Which essentially gets you out of some of those problems because you're thinking about a particular actor. But I did want to go back to American Express, which was a 5-4 decision. Justice Breyer, writing for the dissent, he would have held that the two sides of the credit card market were complements rather than part of the same market. What do you think about that position, and what would it have meant for the kind of one market theory that you're advancing if Justice Breyer's view had prevailed?
Sure. Yeah, so I think in terms of what it would have meant, that's the harder question. Let me put that to the side and we'll definitely get to it. In terms of what he said in dissent. So as you said, he said that they were complements and therefore they can't be in the same market. First time I read that decision, I agreed with Breyer. And I thought this is kind of a head scratcher that the Supreme Court is defining this broader market. Then I read it again. And I'll tell you, I used to be an economic consultant before I was a lawyer. I did, economic modeling, and some of the modeling I did was for two-sided markets. And so it started to make sense to me more then, because there's such a strong connection between what happens on one side of the platform and what happens on the other side, that those markets or those models are very unstable. If you change a parameter on one side, you get a totally different effect on the other side. So it makes sense that you would have to consider them together. In that sense, I totally agree with him. Whether his view that you could have submarkets on each side would view one market per transaction, I'm not sure, right? Because on the one hand, he's relying on Brown Shoe, which did not have any submarkets. So if he's just saying we should have done it the way we did it in Brown Shoe, we would have non-overlapping markets. We would have one market on one side of the platform and another market on the other side. He also mentioned in his dissent, which was interesting, someone had invoked Grinnell. I can't remember if it was in a concurrence or in the majority opinion. And he said, well, Grinnell didn't really reach this question. They don't really have anything to tell us, which I think is correct. In Grinnell, they mention submarkets and they say they're not going to reach that question. But I think if that's true, we should recognize that also applies to Brown Shoe. In Brown Shoe, they mention submarkets, but they don't really reach it.
This is very interesting. And then maybe it's time to bring our listeners back to reality, and then how all this conceptually complicated would be applied to real cases and enforcement. So we're sitting right now discussing at a time where there is maybe some transitions, some potential changes under the new administration. What do you think the new administration would not, you're not holding a crystal ball, we're not asking you to predict what exactly is going to happen, but do you think there are some indications that overlapping markets might be one of those things that the new administration, the current administration, may leverage in support of their goals? And if they want to be right, I guess, according to your argument, they should adopt this one market per transaction rule. Do you think they would be receptive to that?
Yeah, I think they would be. I think we've seen they're hiring kind of experienced economic staff. I think we are going to see kind of a continued focus on economics. And I think as part of that conversation, whether it's EAG or the Bureau of Economics, they're going to have somebody in the room saying this doesn't make sense economically. So I do think there's going to be some receptivity to it. I do think folks are going to want to think about it and are going to want to get to the right answer, an answer that's consistent. I do think, though, just to be perfectly fair, that overlapping markets have been a strategy, like a litigation strategy, that has worked pretty well. And so if you look at some of the cases, like Peabody, for example, which I think is one of kind of the paradigms for this. Peabody was a cold case. It came up while I was at the FTC, although I was not involved in the litigation. But there were kind of two views of the market, right? The defendant said, when you buy coal to generate electricity, you're competing with natural gas and you're competing with all other fuels. So you should count them all together. The FTC took the view from Arch Coal that no, there's a separate market for a particular kind of coal that's mined in Wyoming, and it only competes with other coal mined in Wyoming that has the same characteristics. And the district court said, well, you're both right. It is true both that coal is competitively constrained by wind and solar and natural gas, and that coal is not constrained by those other factors and is only constrained by other coal from Wyoming. And again, the result did not make any sense, but it did mean that the merger was enjoined. And so I think there's always going to be a little bit of tension of how do we litigate this merger in the most advantageous way while still being economically sound.
So Keith, that was very instructive. Overlapping markets are mentioned in the 2023 merger guidelines. Can you talk to us a little bit about how you view those guidelines as a guidepost on this issue and whether it would be difficult to use and apply them given the justifications or really lack thereof provided in the 2023 guidelines?
Sure. Yeah. Whether we should review what the merger guidelines have to say about overlapping markets, yes. And I think John and I are on record on that in the article. I think the current leadership has said that they're keeping them, right? So to some extent, that they're not going to intervene or at least change their mind there. But what is interesting is they said, so Chairman Ferguson said that he was keeping the merger guidelines because they, quote, simply restate longstanding law and the binding rules of the court. And so I think, if you all agree with me that this is not binding law, this is not a holding, then it doesn't restate anything. And there's kind of nothing to be added there. I think Acting Assistant Attorney General Asifi also recognized that the merger guidelines are, quote, not necessarily perfect, and there may be opportunities for revisions in the future. So again, if they were inclined to consider revisions in a narrower sense, I think that would be one to consider. In terms of kind of whether it would be difficult, I think it would be a change of pace. I think we've talked about kind of the litigation reasons for doing that. I think if you were going to litigate this, one option that you might consider, as John Jacobson and I put in the article, is ledging markets in the alternative, right? If the transaction is unlawful, whether the market is all baked goods or cookies, we should not be faulting the government for choosing cookies and having the court decide that actually it was all baked goods, right? If it's unlawful either way, we should not need to make such a firm decision. And so you could imagine a complaint that's in the alternative that says the transaction is unlawful if the market is baked goods, and here's all the reasons why it's baked goods, and the transaction is unlawful if instead the market is cookies. What we really want to avoid is a situation where they're pleading both simultaneously as kind of both being true at the same time, and the court is accepting both as true at the same time. The court really should be making findings of fact about what the competitive constraints are that constrain that defendant's ability to raise prices. And in doing so, they have to decide what is and is not a competitor, and that will naturally bring you to one market. One other thought, just to finish up on that, in terms of what else could they functionally do, the agencies. One idea, I've heard anyway the story, that during Chairman Meares's tenure at the FTC, he banned the staff from citing Philadelphia National Bank in any filings. And I'm not saying we need to go that far.
Unless it's a CF site, right?
I don't know. Well, yes, maybe if it's a CF site, that's fair. Or a BUT-C site, who knows? But anyway, I have been told that the structural presumption was so disfavored during his tenure that staff were banned from citing it. I don't know that we need a ban, but you could certainly imagine a case where that is deprioritized on the list.
This is so fascinating. A little bit feel like back in law school, but it's very good to understand your thinking and your arguments. I think it's very educational. Before I let you go, though, we want to know a little bit about you personally. So, would you tell us a little bit about yourself that, like Blair and I, if we have just known you professionally, we would not know you? Something personal to share with our listeners.
Sure. Yeah. So let's see. I guess what I'd say, I never use my middle initial professionally. I know most people do. The reason I don't is because we made up our last name. We used to have a Polish last name, Konieczny, and nobody could spell it. And so my grandfather made up a new last name that was kind of related. But there are no other Keith Klovers anywhere in the world. So the middle initial is unnecessary.
Oh, wow.
That's a good one. And the alliteration is great. So
that's very useful. I think, yeah, for people who want to trademark your name, maybe they might want to run a search and they will find that it's unique. That's very good to know. So before we end the show, we also play some game in a segment called Our Curious Hat.
And now it's time for the Curious Hat.
So the purpose of this segment is also to humanize you a little bit more, to tell us a little bit that's fun or maybe quirky about you. And then please pick a number between 1 and 20, and each number will correspond to a random question, and we get to ask you about that question. Would you please pick a number?
15.
Question 15. Do you like to dance? And if so, how would you describe your dance style?
I do not like to dance. And if I did, I would say it's a very embarrassing dance, like the thumbs and the points and all that. So, yes, I think that's an answer you probably hear a lot, though.
So playful. We describe that as playful.
Okay, there you go. What are the other alternatives next time, if not playful?
I don't know. Some people are very professional, and you may know one of our co-hosts, Alicia Downey, who is a flamenco dancer.
Okay.
So
I'm definitely not that.
Right. Well, it's very nice to chat with you, and thank you for sharing with our listeners your thinking on overlapping markets. It's very educational, as I said, and also fun. And thank you for listening, listeners. Until next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org. Antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.